everyone. My name is Kelly Byrne. I'm a staff attorney at ASISTA, and I use she, her pronouns. Thank you so much for joining us for today's OVW webinar on immigration remedies for child survivors. I'm happy to be joined for today's webinar by my wonderful colleague, Rebecca Eissenova, senior staff attorney at ASISTA. A few housekeeping matters. Today's webinar is being recorded, and the recording will be sent to all of the attendees after the webinar. All of the materials, including the slides, were emailed to attendees before the webinar. If you don't have the materials, you can request them by emailing ASISTA's program associate, Maria Lazzarino. Maria's email is manager@asistahelp.org, and I'm going to put her email in the chat box as well. This webinar has been approved for 2 CLE credits in Texas. If you are licensed in Texas, we will submit your CLE credits on your behalf. If you are licensed elsewhere, or if you're a DOJ accredited representative, please email Maria after the webinar to request a certificate of attendance to submit on your own behalf. Please do ensure that your full name is included in Zoom if you're seeking CLE credit, since that's how we will verify attendance. As Annette said, we ask that you please only use the Q&A box for your questions during today's webinar. We will be pausing periodically to answer questions, and it'll be much easier for us to see your question if it's in the Q&A box. You may use the chat box to interact with each other, answer our questions, and to voice your thoughts during today's presentation. If we do not get to your question, please review the last slide for information on how to get in touch with ASISTA for technical case assistance. Next slide, please. For today's learning objectives, after participating in this webinar, attendees will be better able to, number 1, understand when and how age is relevant at various points in the survivor-based immigration system, to assess children's derivative eligibility in survivor-based cases, to apply practical strategies to achieve successful discretionary decisions for immigrant children who have had contact with the criminal legal system, and to assess which forms of immigration relief may be best for a child survivor. Next slide, please. For our agenda, we're going to discuss overview of children and immigration. We'll talk about child-specific considerations in UT and VAWA self-petitions. We'll talk about some additional options for children who are outside of the United States. We'll talk about children in inadmissibility, children in discretion, and choosing forms of relief for child survivors. Next slide, please. So just a very brief introduction. Next slide. We're going to start with just a very brief overview of the definition of child for immigration purposes. This is probably review to most of you, but for immigration purposes, a child is a person who is both unmarried and under the age of 21. If the non-citizen turns 21 while the case is pending, depending on the type of relief, there may be age-out protections available. And the specific age-out protection that applies is listed in the statute that creates the form of relief. And those statutes are listed here on your slide. Next slide, please. So age matters for eligibility, both as a principal and a derivative in survivor-based relief, but it can also matter in some other aspects of the immigration system. For good moral character, for VAWA self-petitions, there's a presumption that a child who is under 14 is a person of good moral character. And that means that you don't have to provide a police clearance for a child self-petition who's under 14, but USCIS has said that they do reserve the right to ask for information if they think that the child might lack good moral character. Regarding signatures, most of you probably already know this, but USCIS does allow a parent or a legal guardian to sign a form in place of an applicant if that applicant is under 14 years old. 14 is a very important age, as you're seeing. Children under 14 also generally do not need to provide biometrics, meaning fingerprints and photograph and signature. But keep in mind that some children who are under 14 at filing may have to provide biometrics later on, especially if they've applied for a benefit with a really long processing time. And non-citizens often do need a photo ID for that appointment, so just make sure that your child clients who are approaching age 14 start that process to get an ID so that they'll be ready for that appointment if it comes. Age might also matter for whether a client is interviewed, and interviews often come up in VAWA self-petition-based adjustment of status. So USCIS in their policy manual, which is in your materials, they have a non-exhaustive list of cases where they might consider waiving an interview. And those cases include children, all children of US citizens who are adjusting status, as well as children of LPRs who are adjusting status if they are under the age of 14. And then in terms of special rules for service of notices to appear, so that's for immigrant children who are in immigration court. If the child is under the age of 14, the notice to appear does have to be served on the person who the child lives with. If there's been improper service of that notice to appear, there might be opportunities to challenge it. And now I will turn it over to Rebecca.
Thank you, Kelly. So we can go to the next slide, please. Staying with the theme of some general information on issues surrounding children, we want to talk about derivatives in a general sense, as opposed to for a particular benefit type, and when a child can usually be a derivative or include certain derivatives on their applications. Next slide, please. First, we want to talk about when children can be derivatives on someone else's application. Just a reminder about terminology. Any non-citizen who's submitting an immigration application for themselves, so they're showing they meet the qualifications for the benefit, that's someone we call a principal applicant. And by contrast, a derivative is someone who's related to the principal applicant and is only eligible for the benefit because the principal is applying for the benefit. Most immigration statuses, including all affirmative survivor-based statuses, permit principal applicants to include derivative family members on their applications. And specifically, when thinking about children, all the affirmative survivor-based case types allow parents to include their children as derivatives, as long as they are unmarried and minors under the definition Kelly just went over. And in addition, T and U visas permit minor siblings to be derivatives on a principal siblings application, as long as both siblings and the principal, as long as both siblings are under a certain age. Unfortunately, VAWA does not have the sibling provision though, so it's just children who can be derivatives on VAWA. And there's really only one survivor-based status that doesn't permit any derivative eligibility, and that's going to be defensive VAWA cancellation of removal. Unfortunately, children of VAWA cancellation applicants, they just cannot be derivatives at all. And so they have to either qualify for cancellation and apply on their own or pursue another immigration option. Diving in, a few things to know about filing for derivative status for your child client. Status for the derivative depends on status for the principal. And this means the principal must succeed on their own application first in general, or else the derivative will not be eligible to take up the status. So this also means that if the principal gives up or loses the status later, the derivative might also lose the status. And if the principal dies before the status is granted, the derivative's application often essentially evaporates as well. There are a few exceptions to all of these rules, though, and you should check carefully the law on any given benefit if a situation arises. But these are the general principles to have in mind when talking about dependent derivative statuses. And if you have questions on one of these issues in a specific case, you can actually make an appointment for technical assistance, also called a TA appointment, with our organization ASISTA. We can help you check your research on continuing derivative eligibility. Another general rule is a derivative must qualify as a derivative at the time the principal files their application. Basically means they must have that qualifying relationship of either being the child of the principal, under 21 and unmarried, when the principal files, or they have to be a child still under 18 and unmarried at the time of filing if the principal is their sibling. You may ask, after filing, what happens if the application takes a long time to be approved and the derivative turns 21 when they're a child of the principal, or turns 18 when they're a sibling of the principal? Fortunately, for most benefits, there are age out protections, like what Kelly mentioned, to keep people from aging out of the ability to count as a derivative. Usually, this takes the form of just freezing the derivative beneficiary's legal age upon the filing of the application. That's a pretty simple rule, but unfortunately, there are exceptions and complications to that rule, most notably among U visa derivatives and VAWA derivatives in preference categories. So it is really important to just check the particular age out protections of the survivor-based application and not assume that a child's age is going to be locked in on the date of filing. By contrast, most benefits do not have provisions to prevent derivatives from losing eligibility if they get married. For the most part, if a derivative child gets married before their application is approved, they are not going to count as a derivative anymore. There are some small loopholes for certain benefits, and so if your child client gets married without telling you, it is worth doing a little research or setting a TA appointment with us to check if there may still be ongoing eligibility, but you should definitely generally advise against a child derivative getting married before their application is approved, and sometimes even after it's approved. And then finally, a fun fact about derivatives of all ages, but including children, is that they usually have simplified eligibility requirements compared to the principal. So a big example is with U's, T's, and VAWAs, the actual crime, trafficking, or abuse that forms the basis of that application. It's just the principal that has to have suffered that. The derivative does not have to have suffered that. But there are also plenty of other examples of elements that derivatives don't have to prove. And so for this reason, it really can be easier for someone who might qualify either as a principal or a derivative to just file as a derivative because they'll have fewer things they have to document. There also sometimes are simplified actual procedural requirements too. For example, a VAWA child derivative just has to be listed on their parents' Form I-360 application. There's a box to indicate they're included, and they don't have to file their own form at all. Meanwhile, U's and T's, their derivatives do have to file their own forms, but they're simpler forms than the principal. Basically, the process and the forms are all a little easier for derivatives. Next slide, please. Now I want to turn to when children are the principal applicants themselves. Who can a child principal include as their derivatives? Again, each benefit is going to define this differently, and the best thing that you can do excuse me, is check the rules for each benefit, but there are some common trends, one of which is that children can bring a broader array of their relatives as derivatives than adults can. Often both children and adults can bring a spouse or their own children, but children can also bring their parents and siblings who are unmarried and under 18. A big exception for this one is going to be a child applying as a VAWA self-petitioner. That's because the only type of derivatives for a VAWA self-petition submitted by someone of any age is going to be that person's child or children, regardless of how old they are. Now, for determining which derivatives a person can bring, the person will count as a child and have those extra options for derivatives if and only if they file when they are still under 21. So jumping down actually to the second bullet point on this bottom half of the slide, what's a little funky here is they don't actually have to file while they're still unmarried in a lot of cases. For VAWA, they do, but for instance, a married person applying for a U visa when they're under 21, they can still include their parents and siblings under 18 as derivatives, even though they technically don't meet the definition of a child because they're married. Returning to the bullet point above with the last slide, if a principal is a child under 21 on the date they file, most benefits have age out protections afterwards. So nothing will change if processing delays cause the principal to turn 21 before adjudication. However, that is not 100% true, of course, of all survivor-based relief. So you have to check, and a big example of this one with no age out protections is going to be for U-based lawful permanent residency petitions using Form I-929. That's a child with a U-based green card trying to petition for their parent to also get a U-based green card. Child has to be under 21 when they file, but also all the way until the parent's adjustment of status is granted. And there are no age out protections to guard against processing times, frustrating that. And then just one last thing on derivatives, I want to emphasize that the key moment in which the principal or the derivatives have to meet these age and marital status requirements is going to be the date of filing, sometimes the date of decision as well. And that is important to remember because it's different from some other points of reference that we'll be talking about today. Later, we will focus on the child's age when the crime or trafficking occurred. And that's for the principal's eligibility for certain aspects of the benefits. But for derivative rules, we are always talking about the age on the date the principal files their application. And just remember, if you have a child in your office and you are pleased, oh, we don't have to rush to file this to lock in their eligibility as a principal because the only point of time that matters is the date of victimization. Not so fast. Remember, you may still want to rush to file if your child client wants to bring as broad a range of their family members as derivatives as possible. Next slide, please. Okay, so the final thing just to keep in mind with derivatives is even if all other requirements are met, the perpetrator in a U visa crime and the trafficker in a T visa crime can never be derivatives. And the same actually goes for the perpetrator of abuse or extreme cruelty in a VAWA case. And that's true even if the perpetrator or family member may be genuinely reformed and the relationship is entirely repaired. It doesn't matter. All right, next slide, please. Okay, so let's do a case scenario together. I am going to read the scenario out loud and then invite you all to put some ideas into the chat box, not the Q&A box, please, the chat box. And I'm going to also ask Kelly to tell us what she would do on these facts while you all are typing your ideas in the chat. Okay, so we have a child client who's 14 and unmarried, and he's considering applying for VAWA protections on an I-360, an affirmative VAWA application. He, his mother, and his siblings have all been victims of the same domestic violence from the same person who's the mother's partner. That abusive partner is a US citizen, but he's not your client's biological parent, although he is the parent of your client's siblings. So the question is, again, put your ideas in the chat. What are some considerations for deciding between the client filing as a principal self-petitioner or as the derivative of one of these other family members who could be the principal? Just what are some considerations? And as you type in the chat, I'll turn it over to Kelly. I see some thoughts already coming in.
Thanks, Becca. So first, I think you'd want to consider, could this child even be a self-petitioner or a derivative? If only one of them is available because of the eligibility requirements, then you have your choice already. Here for the self-petition, the question, is this client considered a child of the abuser? The facts don't say, you'll notice, if the mother is married to the abuser or not. If she is, then the marriage must have taken place before this child was 18, meaning that this child is considered the abuser's stepchild. And under the Immigration and Nationalities Act definition, Nationality Act's definition of child, a stepchild is considered one. So self-petition in that case would be possible, at least as far as the qualifying relationship element of VAWA. If we're talking about a derivative, the question would be, who would be the self-petitioner who would include this client? For U's and T's, like Rebecca was talking about, an unmarried child who's under 18 can be a derivative on their siblings' applications, as long as that sibling is under 21 when they file. But only children of the principal can be derivatives in a VAWA self-petition. Rebecca said that sibling option is not there. So the mother would have to be the self-petitioner in order for the client to be the derivative. And the client's ability to be a derivative then obviously would depend on whether the mom could be a self-petitioner, which again, unless there's an intended spouse rule, which probably is not the case, but unless that's the case, she would have to be legally married to the abuser or divorced within 2 years, as well as is she interested in even filing for a VAWA self-petition. If mom is willing and able to file, it seems like the child is likely to qualify as a derivative because he's under 21 and he's unmarried. Another thing you want to think about is how likely is each type of application to succeed. Does mom have some sort of impediment on succeeding on the self-petition? Does she have a good moral character problem, for example? Can she document all the elements, or is she going to have a lot of difficulty documenting, say, a good faith marriage? If it's unclear that mom's self-petition would be approved, it might be better off to have the client do his own self-petition if he's eligible. And that's because if someone's a derivative, generally it means if the principal's application fails, then the derivatives also fails. And by the same token, then what evidence is there that your client meets the definition of a self-petitioner? Sometimes if you're talking about a child self-petitioner, there might be less evidence. So that's something you want to factor in. Can the child submit enough evidence to be able to qualify? And then similarly, what is, in terms of having mom be principal or child be principal, what's the likelihood that mom maybe fails to follow through on the self-petition? For example, is it possible that she'll either want to or feel compelled to return to the abuser? If the principal may not succeed on that self-petition, again, the client might be better off filing as a derivative. And then another consideration when you're working with a client this young is that survivor-based relief generally requires this applicant to describe what happened to them. And any person who suffered trauma might find this difficult, but that's especially true if we're talking about children. As trauma-informed lawyering, that would demand that you do take this into account, as well as the practical ability of this client to describe the abuse sufficiently in order to be approved. But those concerns are especially pronounced again when you're working with a child. So you'd want to be thinking about what is this particular 14-year-old's maturity level, how traumatized are they, how articulate are they? And if the child has had some problems with being expressive or articulate, is there a possibility that things might improve if you wait a few years, if the child has therapy? That could be appropriate depending on the client's situation, whether they're vulnerable to removal, for example. If you did that, though, of course, you'd want to keep an eye on the child turning 21 or getting married, because then they would be ineligible. And just in either situation, you'd want to caution him against getting married, because that could jeopardize him both as a principal and as a derivative.
That was great. That was very comprehensive. Thank you, Kelly. And thank you, everybody. You all identified we need to know people's ages in this hypothetical and marital status. So well done, everyone, and thanks for your participation. We can go to the next slide. Yes, and we are going to then end our section on kind of general information about children and move on to talking about children with specific survivor-based benefits. We're going to start with the U visa. Next slide, please. So a quick reminder of which people, of who is eligible for a U visa in general, whether they're a child or not. So they have to prove that they were the victim of a certain type of crime, which appears on a statutory list, usually of particularly violent or serious crimes, and that's called a qualifying crime. So they have to be a victim of a qualifying crime. They have to have information about that crime, and they have to have cooperated with law enforcement regarding the investigation or prosecution of that crime. And in particular, they have to cooperate well enough that a law enforcement agency would be willing to sign what's called a certification or supplement B form, confirming or certifying this cooperation. Third thing, they have to prove they suffered substantial harm because of the qualifying crime. And fourth, they have to show they are admissible, or else they have to get a waiver of inadmissibility. Those are things that anybody has to prove for a U visa. And for children, they have to meet those same requirements, but there are a few ways that they might meet them differently than adults. And in the first is this requirement to cooperate with law enforcement. So what's different for kids is that if they're under 16 when the crime occurs, They do not have to personally have information about the crime or be helpful in the investigation. And instead, their parent, guardian, or next friend can do both of those things for them. And this does not amount to a full exemption from the rule that there has to be law enforcement cooperation. In this way, it's different from a T visa, but because the difference here is the crime has to be reported to law enforcement and someone has to be cooperative in the investigation and sign. They have to get this signed U certification still, but for children, it's just that someone, it doesn't have to be the child themselves. Next slide, please. And another difference is that children who have suffered crimes may have more options in terms of who they can approach to sign that required U certification form. Like anyone, a child could approach the police, and if their case goes to trial, they might also be able to approach a prosecutor or a criminal court judge and ask them to sign a U certification. They might be able to approach a family court judge if the crime was domestic violence and the child got a protective order from the judge, or if the state happens to handle domestic violence claims or cases in family court. But a really big and sometimes useful option for children is your state's Child Protective Services Agency. That has a lot of different names in different states. It might be called Department of Children and Families, Child Protective Services. Whatever it's called, it's the body that investigates reports that come in from mandatory reporters and others about whether child abuse has been happening. And this kind of agency is specifically authorized as a certifying agency by regulation. And this is great because many times a family might not have reported domestic violence to the police, but may have had some involvement along the way with a child protective agency. And if that's the case, then assuming what was reported to that agency was in fact domestic violence or another U visa qualifying crime, then you can request the head of that agency to sign the certification form without needing a police report ever to have been made. And this can be quite useful too, just as an additional option, because as many of you, it's unfortunately common to learn that a certain police department or prosecutor's office or court has a policy that says we don't sign U certifications, or at least they don't sign them in cases like your client's case. And it's also not uncommon for certain law enforcement records to be written in ways that are less than ideal for your client. They might mention something negative about your client, or they might not describe the crime in the detail that you need. And for either of these types of problems, having an additional agency to potentially work with that may have written a different type of report that could be more favorable, that can be really game changing for a U visa. So next slide, please. The third difference when your client is a child from an adult is that the event they suffered might count as a qualifying crime for a U visa, even when the same thing would not count if it had happened against an adult. So some crimes like that are listed here. We see statutory rape. That can be certified as either rape or sexual assault, and it can be the basis of a U visa. Also, sexual exploitation, which at least federally is defined as causing a minor to engage in sexually explicit conduct for creating a visual depiction, so pornographic portrayal. And then there are also some states that make simple assaults when they're committed against a child into a felonious assault, which would then become a qualifying crime. And there are lots of examples of states having child-specific versions of other crimes that are listed on the U visa statute. They'll have different elements when the victim is a child. And all of that can be helpful to keep in mind, especially if you have a child client and you've got the reports from law enforcement of their victimization. Even if a crime wasn't charged in a way that makes it an obviously qualifying crime, there may be a child-specific qualifying crime that was committed against them and that your law enforcement agency might still be willing to certify as having been detected in the course of the charged crime, or saying this event involved that child-specific crime as well, and that would open your child up to U visa eligibility. All right, next slide, please. And we are going to do a poll with this one. The scenario is your client is 10 and unmarried, and they were the victim of domestic violence. A teacher called Child Protective Services, which brought the case to police, and then a conviction resulted against the abuser. The question, if we could please launch the first poll, thanks. Question is, who could sign the U certification? I'll give you about 15 seconds to answer. Another 5 seconds when I get your votes in. Okay, and let's close that poll. And it looks like almost 90% of people answered all of the above. Very good. That is true. You would have 4 choices in this case. CPS, police, prosecutor, and judges, they're all potential U certifiers. And so you would make a choice of who to approach for the certification by reading their reports and maybe considering their internal policies about how they process U certification requests. That will help which one to go to first. All right, next slide, please. We've got the same facts here. Again, child age 10, unmarried, victim of domestic violence, teacher calls CPS, which brings the case to police, and a conviction results. The question this time is, with your child's U visa, who could be included as a derivative? I'll give you about 20 seconds. Get your answers in. And let's go ahead and close that poll. All right, so this one was harder. I'm not sure that I really emphasized a key part of this answer here. Audience was almost evenly split here between the 2 middle answers, B and C. In this case, the answer is B. And that's because the rule about siblings is that they stop being eligible as derivatives once they turn 18 or they get married. And that's different from the other rules about children, which all turn on being age 21. So I totally understand why this is confusing. I often have to check as well, but the answer is B. They can include unmarried siblings under 18 and their non-abusive parent. The reason it's not D is that the perpetrator of a crime can never hold a U visa based on that crime, and that's regardless of their rehabilitation and even if no conviction resulted. So great job, everyone. Thank you. And we'll go on to the next slide. Okay. So now I want to talk about when a child is not the target of a crime, but may still be eligible to file for a U visa. And the first way this can happen is if the child qualifies as what's called a bystander victim. And a child's a bystander when they are not the target of a crime, but they still suffered proximate harm that was unusually foreseeable and direct. It does not inherently matter who the target was. For instance, the target victim could be a US citizen, could be a family member of the bystander or not. That's not inherently a requirement one way or the other. The real requirement is, did the harm that they suffered meet the definition of being proximate and unusually foreseeable and direct? Prototypical example of a bystander victim is a woman who witnesses a crime while she's pregnant, and then she has a miscarriage. You can see that's a very direct and serious harm that is foreseeably so, right? It's foreseeable that someone who's pregnant and experiences a trauma might have a miscarriage. But that is a dramatic example, and it's not the only type of situation where someone can get approved. Bystander claims are difficult to make, but they're not impossible. And some of the helpful factors are on this slide. So if the bystander was present or close in proximity, in time or space to the crime, the person has a close family relationship to the target victim, if the target victim suffers severe and lasting injury, and I would say especially so if the bystander has to live with them or in some ways continue to be affected by that injury as well. So maybe they care for the target victim, or maybe the target victim would have cared for them, might be their parent who is now debilitated by the crime and so cannot adequately care for the child anymore. Another factor might be a severe or lasting injury to the bystander. Also, some things not on this slide, if the perpetrator had previously threatened or harmed the bystander, or if the bystander was previously aware of and maybe even tried to prevent the threat against or crime against the target victim, that can be a helpful factor. None of these things are required, but these are some examples of helpful facts that could make out a bystander claim. But just remember, a bystander victim is a subset of a principal U visa applicant, and that means they do have to meet all the other requirements of a U visa, and they would be filing their Form I-918 with a U certification in their own name as a U1 principal. All right, next slide, please. The other situation where a child doesn't have to be the victim, or sorry, the target victim of a crime is if they can count as an indirect victim. And for this one, a main requirement is that the applicant child has to have a particular family relationship with the target. And the next slide is going to explain what that relationship would be, and it's going to vary based on how old the victim was when the crime happened, but it has to be a family relationship. Another key requirement is that the target victim has to be unable to help in the investigation themselves. And that has to be either because they were killed in the crime or because they are incompetent or incapacitated to cooperate with law enforcement investigations. And that can be for whatever reason. It doesn't have to be that the crime rendered them incompetent or incapacitated. And of course, unfortunately, immigration law does not make this simple because the definition of incompetent or incapacitated does not track the typical legal definition that says children are incompetent. So it's not the case that any crime where there's a minor as a target victim, you would be able to make an indirect victim claim. It's not the case. Instead, this definition is more related to what we touched on in the first slide of this U visa section. So remember, we discussed how a child target victim who's under 16 when the crime occurs, they can have their parent, guardian, or next friend stand in for them on the cooperation requirement. With indirect victims, if the target victim was under 16 when the crime occurred, they are basically presumed to have been incompetent. And so in that regard, this indirect victim law very much jives with that age 16 threshold for being able to cooperate by yourself with law enforcement. But the difference is here, this is just a presumption instead of an actual rule. And so this presumption can be rebutted. And that can happen if there's facts in the record that show the target victim, although they were under 16, did actually cooperate with law enforcement, was able to be helpful, then an indirect victim would not work. They would not be incompetent or incapacitated. So look out in your reports for those surprisingly helpful or expressive young victims. And then finally, just as before, an indirect victim child would need to meet the other elements of a U visa as well, and that would generally include helpfulness. And I would say the usual helpfulness assessment would be summarized by saying an indirect victim is supposed to stand in the place of the direct victim and be helpful instead. But I want to pause here and forgive me because this might get a little complicated, but remember, we're talking about children being indirect victims here. We just said the helpfulness requirement is different for kids. Kids are presumed to be incompetent if they're under 16. what if your target victim and your intended indirect victim are both under 16? Can the target victim then be presumed incompetent so that the indirect victim child can make this claim? And then can the indirect victim also get out of having to be helpful and have their own parent, guardian, or next friend stand in for them on the helpfulness requirement? There is unfortunately not a clear official policy on this. There is no obvious reason in the statute why this couldn't work. The regulation on indirect victims says that a target victim has to be incompetent, and it does not say that an indirect victim has to not be incompetent. Really, it just says that when a direct victim is incompetent, then certain family members can count as victims. And so that should suggest that they could apply using all the same exceptions and special provisions that apply to any kind of victim. It's the same word being used. But I will say there is at least one AAO case, so Administrative Appeals Office case, where the target victim and the indirect victim were both under 16. And in that case, the AAO examined whether that indirect victim had been helpful just under the traditional markers of helpfulness. So it didn't apply the rule that a parent or next friend could have stood in for them. We don't know why. We don't know if the indirect victim in that case maybe didn't ask to use the exception for being under 16. Maybe they made their case clearly asserting their own helpfulness, and that's why the AAO analyzed it that way. Maybe it would go differently if you tried to make the claim. But because that case is out there, if you've got someone in this scenario, you're going to have to be a little cautious about going out on a limb and trying to claim that both under 16 victims get to use special circumstances. And if you've got this, feel free to set a technical assistance appointment with us to discuss it and discuss arguments that you can make in light of your facts. And then just one more point on having to meet all the other elements of a U visa. This does mean that the indirect victim will have to prove they also suffered substantial harm because of the crime. And that can sometimes be a sticking point too. I wouldn't say that it's really assessed differently, though, for children than from adults. I think maybe children's vulnerability to traumatization and other mental harm, that could be pointed out and documented if it's relevant to your case. But for the most part, it's the same regulatory factors that would apply, and it's just that some would be more salient for children. Okay, next slide, please. So I wanted to give you another way to visualize who can be an indirect victim. We see here at the top, the first rule is that the target victim has to be deceased by homicide, or else they have to be incompetent or incapacitated for any reason. On the left, we see that if the target victim is under 21 when the crime occurred, then next box down, people who could be indirect victims are the spouse, child, parent, or sibling under 18. On the right, we see that if the target victim was 21 or over when the crime occurred, then the indirect victim could be only their spouse or their child. But either way, no matter who they are, the requirement is an indirect victim has to cooperate with the LEA or else try to take advantage of an exception to that. And they must meet all elements of a U visa application and file as a U1 principal. All right, next slide, please. Next slide. Thank you. Sorry. Again, what we're going to do with this practice scenario, I will read it to you, ask you to put your ideas in the chat, and then I'll also ask Kelly to help us out. This time we have a 15-year-old client who was the victim of a sexual assault, and he was able to tell the police who did it, but he cannot bring himself to discuss what occurred with the police. He has been able to discuss this with his mother, though, and his mother's also undocumented, and she has relayed her son's disclosures to the police, and she is willing to testify in court. In this case, the 15-year-old has two siblings, and they are 17 and 20. So first question for the chat and for Kelly, what are going to be your top considerations if you're thinking about filing this application with the 15-year-old as the principal applicant? What would be the benefits of going in that direction? And what would be the drawbacks of trying to use him as the principal? And yeah, if you want to start typing, please go ahead. And Kelly, if you want to start us off.
I think the benefits of including the 15-year-old as the principal are that often direct claims are easier in general. Law enforcement agencies are more likely to sign. It's just more straightforward to them than having to do this, indirect victim explanation. Substantial harm is also easier to prove to the target of the crime often. In this case, although the child is not being helpful, he is under 16, so he gets to take advantage of that regulation that Rebecca talked about, permitting his mom to be helpful. Also, he is still a child, and because of that, he's unlikely to have a lot, or maybe not even any, grounds of inadmissibility or other negative discretionary factors that would prevent him from getting his case approved. So the likelihood of success might be greater. That is assuming he can stay out of trouble during the 10-year processing time for a U visa. In terms of drawbacks, he can only include his mother and his one sibling as the derivative. The sibling who's 20, unfortunately, would be out of luck, because as Rebecca said, a sibling can only be a derivative until they're 18 years old.
Okay, very good. That makes sense. And I know people put in the chat talking about, yes, his level of cooperation with law enforcement. Thankfully, his young age might help him get out of that issue. So what about if you wanted to file with the mother as the indirect victim? And what would be your top benefits of doing that? And what would be the drawbacks?
So I think the benefits would be that mom clearly has been helpful in this scenario. And because she's the parent, because she's 21 or older, she would be allowed to include all three of her children as the derivatives on the application. And that's the way that 20-year-old sibling will be able to be included. In terms of drawbacks, we see that the direct victim is 15. So he is still covered by that presumption, but it is rebuttable. And USCIS probably will scrutinize how much did he actually help in the investigation. The fact that he helped at all, or are they going to say that that means that he's not incompetent or incapacitated? On these facts, I'd say it's possible that USCIS could deny, but it's more likely that you get a favorable result. Took it up on appeal to the Administrative Appeals Office because they've been pretty consistent in cases even where the indirect victim cooperated, still finding them to be incompetent or incapacitated if they're under age 16. Also, the mom might have a harder time meeting those other requirements of the U visa, for example, substantial harm. She'd want to look at the regulation 8 CFR 214.14 B as in boy 1, point to as many factors as apply to her, and potentially get a psychological evaluation that really connects any types of diagnoses or symptoms she has to the child's victimization. Because she's an adult, she also might have more inadmissibility grounds to waive. In this case, she has 3 minor children who are undocumented, so it's possible that she has a smuggling ground of inadmissibility at the very least. And like we were talking about, mom's the principal, that means the derivatives ride on her coattails, and if she gets denied, that means the derivatives are also denied. So that's something to think about.
Mm-hmm. That makes sense. Folks did cotton on to this being a way to include both siblings and that being a major benefit. So great job. And then one person writing just to the host and panelists anticipated our next question, which was, what if they both filed as principal applicants? What would be the benefits of doing that and the drawbacks?
The benefits would be you hedge your bets more if you're doing both. In the case that one is denied, or even that, especially the adult principal passes away before approval, unfortunately, with these really long processing times, that's becoming more of an issue. That would create more favorable circumstances if they both apply. Also allows, that's the only way that, at least mom applying, that's the only way the 20-year-old gets to be a derivative. In this particular case, there might not be a ton of direct drawback. A case where there might be more drawbacks is, say that you have a case where the direct victim was 17, so they couldn't take advantage of that rule that the parent can stand in their place and be helpful. So they'd have to show helpfulness of themselves. they did that, but then the parent also applied as an indirect victim, those two claims would be contradictory to each other. So that can cause some problems. We don't have that here, though. But keep in mind that whether the direct victim did apply for U1 status is a factor that the AAO takes into account when deciding whether someone's a direct victim. I don't think it should be determinative, especially if you have lots of other good arguments, but that is just something to keep in mind. And another really general drawback is we're thinking about the backlog. More principal applicants does add to that for the U visa backlog. If you could think of a good, strategic reason to have both apply, that's fine. But it's not necessarily going to be the case that you want to always have multiple principal applications in the same family.
That makes sense. All right, very good. Good job, everyone. Thank you for your thoughts there. And thanks, Kelly, for walking us through it. Let's go to the next slide, please. And we want to just quickly cover what happens if the person who's a child in your U visa case isn't, or it might be the applicant, but what if it's also a perpetrator? The good news is that a U visa is still available where the perpetrator is a child, even if that perpetrator is, charged as a delinquent and not in criminal court. That doesn't mean that what the victim suffered wasn't a crime. It just means the perpetrator is not being held accountable in the same way by the criminal justice system. And so the victim certainly in this situation can still get a U visa. But the less good news is that many states have strict confidentiality provisions surrounding records of child delinquency. And these prevent disclosure of records even vis-a-vis the victim in the same case a lot of times. And so not being able to get this record that you are supposed to submit with every U visa application can be a problem. It can be a problem for getting the certification from law enforcement sometimes, and it can be a problem, even if you get that certification, for getting USCIS to approve it. And say that if you do get the certification, maybe law enforcement can check their own records without disclosing them to you, verify they were a victim and still sign the certification. If that's the case, you can submit the application to USCIS without the records, and you can keep working on trying to get the records while the application pens for, unfortunately, many years. I think in some states it is possible to get the victimization records by filing certain motions with the court. And so you might end up getting them and being able to respond to any RFE that USCIS might send for them. And we've also heard of approvals even where no records can ever be disclosed. But if you have this type of situation and you need help, I would say that the best place to start is by finding a local practitioner who has dealt with the same law enforcement agency on this issue and asking them what worked for them to get those records in the past, because it is going to be very jurisdiction specific. And if you need to find local practitioners, just a plug, we have a great active listserv of people from around the country. So you could join, and as OVW recipient, it would not cost money. You can connect with experts around the country. Next slide, please. We will, oh no. This slide was supposed to have the answer hidden, but we'll still walk through it. It's a gimme for you. Good job, everyone gets A's. But the issue here was supposed to be your client was 16 years old and was the victim of stalking at school. She tells the school resource officer about the issue, and they help her confront the stalker, who is another student. Because they're all students, the matter is dealt with internally through school discipline, and the only punishment is suspension and not criminal charges. And the question is, in this scenario, could that school resource officer sign a U certification? As you can see, I think that the answer depends. The officer, in order to sign, would have to be part of a certifying agency under the regulations. And often they are. Often they're part of the local police department. And they would also have to be authorized to detect and investigate criminal activity. But if both of those things are true, then I would say that the fact that no criminal charges resulted and everything was just dealt with as school discipline, that's not going to hold back or be what affects whether the school resource officer can sign. Because there's never any particular prosecutorial outcome that's required. It's just that a certifying agency has to detect a crime, and that could be what happened here with stalking. All right, next slide, please. Sorry for not giving you a chance on that one. Yeah, and we want to pause for any questions here. I have not been able to very actively manage looking at the Q&A. Kelly, is there anything that you wanted to pull out and answer for folks now?
Sure. So I'll just go in order. For now, the first question that came in, and by the way, thank you everyone for participating so actively. If children under 14 are sent biometrics notices and do not have an ID or proof of identity, what can we advise them to do? So that's a great question. The USCIS policy manual, when they're talking about biometrics, which I think that's in your materials, they talk about needing a photo identification. They don't necessarily say it has to be a government issued ID. So if the client has, for example, a picture ID from school, they could maybe bring that in conjunction with their birth certificate to the biometrics appointment. We've also seen on our listserv, there's been success with some attorney offices where the attorney does an affidavit attesting to the identity of the child client, and then the client brings that to the appointment. The policy manual also notes that in some cases, if someone is classified as a special immigrant juvenile, they might not have a government photo ID. And in that case, they might accept, or they will accept, potentially evidence of a court order citing the SIJ as the subject of that order, or some sort of official documentation issued by the Department of Health and Human Services for people who were children who came to the United States and were put into the custody of that agency. So they were an unaccompanied minor. While the policy manual says this applies to SIJs, I think it's worth trying this if it's not an SIJ case, but you do have a client who was in ORR custody, has a document with their photograph, their name, their age. You can also potentially, depending on the country, try to get an expedited appointment at the consulate to get a consular ID or passport, depending on how soon the biometrics appointment is. That might not always be possible, but those are some potentials. There's a question about, are there limits on how many derivatives can file per principal? So I'm going to assume that here this is basically, is there a limit on how many derivatives you can file for as a principal? The answer to that is generally no, as long as they meet whatever the statute defines as who can be a derivative. The one unknown is that it's a little unclear whether a child can file for both biological parents and a step parent as derivatives. That's a little unclear. I'd say based on the plain language of the statute, a step parent is still a parent, and so is a biological parent. But again, that gets a little bit more complicated. There was a question, are U derivatives, so meaning minor children who are abroad, age out protected when the U visa is finally approved and it is time to consular process into the US? This is a great question. This comes up a lot in our technical assistance. It depends on whether that derivative turned 21 before or after the principal's 918 was approved. So if they turned 21 before the principal's 918 was approved, then yes, they're age out protected and they don't have to worry. The issue is when they turn 21 after the principal's 918 is approved. In that case, they're not age out protected. If you have a case like this and the child is going to age out soon, regardless of whether you're at the USCIS stage, you're still waiting for the 918 approval, or if you're at the consular stage, that's a reason to request expedited adjudication. And we would also recommend that if you're in this situation to contact us for technical assistance, because there's some circumstances when, depending on the case, we might be able to intervene if there's an expedite request. Becca, were there any you wanted to take?
I think there's a question about VAWA case being filed by someone who's a minor at the time, and then and included as a derivative, but then their principal cannot adjust. What happens? I want to say, I think we're going to address this to some degree later because we're going to cover the Child Status Protection Act and its application to VAWA, but probably yes, although it will depend a little bit on your facts. I think there's a question, if someone other than the child is requesting a U certification from an agency, does that person have to have specific knowledge of the qualifying crime, or are they reporting on behalf of the child? So if it's both, they can be reporting on behalf of the child, but they're going to have some knowledge about the qualifying crime if they're going to be applying as a principal themselves. But that's not to say that knowledge has to come from any particular source. It may be that the child is the source of that knowledge of the crime, and that's fine. But an applicant has to get a U certification in their own name. So they're going to have to be helpful personally and give information about the crime in order to get that U certification. And I see a question in the chat, and if possible, just a friendly reminder to send questions to the Q&A box. Question in the chat is what number to call for technical assistance with ASISTA, and I believe our last slide will have information on this, but it's not a phone number. It is through a portal that we have on our website. So check out asistahelp.org. And last thing in here, we did pop into the chat the regulation on substantial harm. If you want to take a look at the factors that should be considered for that, that's in the chat. I think that's it for now, but if we didn't get to your question yet, feel free to re-up it, and we'll try to get to it later.
Thank you, Rebecca. Going back to the question about the VAWA case, we are going to cover Child Status Protection Act. We're not going to cover, there's also a separate provision in the VAWA statute that allows a derivative who turns 21 to become a self-petitioner in their own right. And that's helpful if a parent cannot adjust. So if the parent, they still have to have the approved VAWA, obviously, but there's some impediment to the parent adjusting. Once the derivative turns 21, they'll be able to adjust, and depending on whether the abuser is a U.S. citizen or they'd be an immediate relative or a preference category. But if you have this specific question, feel free to make an appointment with us for TA. Next slide, please. Now we're going to switch gears and we're going to talk about T visas. Next slide. When we're talking about T visas, age is important in a couple of circumstances. The first is when you're determining whether a survivor's commercial sex act amounts to what's called a severe form of trafficking in persons. You do not need to show that the commercial sex was induced by force, fraud, or coercion if the survivor was under the age of 18 when that commercial sex act occurred. And keep in mind that you do still have to show that the sex was commercial, but this term commercial only requires that something of value was exchanged. There's no requirement to show that money changes hands. There's also an exception to the law enforcement cooperation requirement for T visas only, if at least one of the acts of trafficking occurred when the survivor was under the age of 18. And this is one place where the USCIS policy manual has actually been really helpful, because this interpretation of at least one of the acts comes from the policy manual. It's actually a pretty generous interpretation of the statute, so hopefully it'll be a long-standing one. But just I think it's in your materials, the policy manual. You can take a look at that if you have the situation. Next slide, please. So now we have Diego. He is 15 years old and he's transitioning. Hormones are necessary for his mental health, but he lives in a state where gender-affirming care is banned for minors. Diego cannot travel out of the state for care because he is undocumented and the roads are littered with Customs and Border Protection checkpoints. Joseph, who's a friend of a friend, recently approached Diego at a party, and Joseph said that he would give Diego testosterone if Diego went all the way with him in the bathroom. So Diego agreed and he received the testosterone as promised. What do we think? Was Diego a victim of sex trafficking? And do you mind watching the poll in it? Do you have the poll? Thank you. Okay, so give folks about 30 seconds to answer. Okay, looks like we've reached pretty critical mass here, so we can go ahead and close the poll. So I see 67% of you said yes, he is, and that is the correct answer. So let's talk about why that is. First, was there a commercial sex act? What do we think? Feel free to put your thoughts in the chat. Folks are saying, yeah, and that's right, because a thing of value was exchanged, the hormones. And we know that hormones are a thing of value specifically for Diego because he's transitioning and he needs them for his mental health. So we have the commercial sex element. What about, do we have to show force, fraud, or coercion? What do we think? People are saying no need, right, exactly, due to his age. So this shows that if you have circumstances where there was clearly problematic conduct that occurred, but it might be a little difficult to show the force, fraud, or coercion based on your facts, you might still be able to get a T visa. There's commercial sex and the survivor is under the age of 18 at the time it occurred. Next slide, please. So now we have Amal. She entered the United States in 2021 as a 15-year-old unaccompanied minor. Immediately after entry, she started working at a poultry processing plant using papers that falsely stated she was 19 years old. The long hours took a toll on her schoolwork, so when she was 17, she went to her supervisor's office to tell him that she was quitting. Upon hearing of Amal's plans to quit, her supervisor sexually assaulted her and then said, "I know where you live, and I'll be giving you some more if you leave." Amal is now 18. She's still working at the plant, and the trafficking is still going on. What do we think? Is Amal required to report her trafficking to law enforcement? We have 5 more seconds. Okay, we can go ahead and close it. So I see 67% of you said no, and that is the correct answer. So we see that Amal is now 18, but that doesn't actually matter because remember, according to the policy manual, the test is whether the person was under 18 when at least one of the acts occurred. Amal's supervisor labor trafficked her at 17 by using force and coercion, that is sexual assault and threats of serious harm, that is further sexual assaults, for the purpose of subjecting her to involuntary servitude. It also doesn't matter that the trafficking is continued because, again, only one of the acts of trafficking needs to have occurred when the person was under the age of 18. And then feel free to put your thoughts in the chat. Do you see any potential problems with Amal's case if she wants to take advantage of the cooperation exception? And then while folks are putting that in the chat, one thing that may come up is that Amal's evidence that she was working at the plant at the time of the trafficking, for example, pay stubs, W-2s, time cards, they might falsely present her as having been 18 years old because remember, she used these false papers that said that she was 19 when she started working there. Now, I don't think she has to affirmatively raise this if the documents don't actually say how old she is. But if they do, and if USCIS makes an issue out of this, namely saying you're not eligible for this cooperation exception because you were 18 or older, she's going to have to overcome that. And the any credible evidence standard does apply to T visas by virtue of the regulations. So Amal would need to submit other credible evidence that she was in fact 17 years old at the time of that assault and threat. She could do that by submitting a statement from herself and potentially statements from other people who had knowledge of her age on that day of the assault. And then in your cover letter, you would need to argue why the evidence that you've provided is credible. Next slide, please. Next slide. So when we're talking about VAWA self-petitions, most of that one of the qualifying relationships is a child of an abusive US citizen or lawful permanent resident. Like Rebecca talked about before, a stepchild is included in that definition of child. And in 2021, the 7th Circuit held in a decision called on Arguijo, which is here listed on your slide, that the stepchild relationship for VAWA purposes survives divorce. And USCIS decided as a policy matter in 2022 to apply that decision nationwide. One note about stepchildren in VAWA, there is no intending stepchild protection. There is for intending spouses. But if there's an intending spouse who's filing a VAWA self-petition, they can include their child as a derivative. You'll also see that for child self-petitioners, there's this requirement that the abuse must have occurred when the child was residing with the parent. And that comes from the regulations, not from the statute. ASISTA's position is that regulation is ultra vires of the statute and should not govern. And that's because the VAWA statute was actually updated specifically to remove this residency requirement for child self-petitioners, but the VAWA regulations have not been updated to reflect that. In your materials is an ASISTA comment on the VAWA changes to the policy manual that has some arguments you can use if you have this type of situation. And also feel free to contact us for TA in that case. Next slide, please. So now we have Maya. She is 20 years old and unmarried. Her mother married Stephen, who's a US citizen, when Maya was 12 years old. Stephen sexually abused Maya for years, starting when she was age 14. Maya's mother divorced Stephen when she found out about the abuse. Is Stephen a qualifying relative for Maya's VAWA self-petition? What do we think? Okay, and go ahead and close the poll. So 67% of you said yes, and that is the correct answer. So great job. And the reason is, let's go through the steps. First, we see that Maya is 20 and she's unmarried. So she's considered a child for immigration purposes. Stephen and Maya's mother married before she was 18. So she's within that definition of stepchild. And then the step-parent relationship now survives divorce. So that means that even though Stephen and Maya's mother have divorced, Maya is still considered Stephen's child for VAWA self-petition purposes. Next slide, please. We've been talking a lot about you got to be under 21. What if you're not under 21? Congress has created a helpful exception to this under 21 rule for VAWA self-petitioners. You do have to prove a lot of things to get this exception, as you can see here on your slide. The biggest obstacle may be proving that the abuse was one central reason why the VAWA self-petition was not filed on time. You'll need to prove this with any credible evidence, which could include a statement from your client and potentially additional corroborating statements from others who had knowledge of the situation. And remember, just generally, that statements of counsel are not considered evidence. So you will have to do more than just argue in your cover letter that abuse was one central reason for that filing delay. Next slide, please. So Sandra's father, he married Alice, a lawful permanent resident, when Sandra was 10 years old. Alice emotionally abused Sandra until Sandra got married and moved out of the home at age 20. Sandra and her wife divorced 2 years later, so when she was 22. Sandra is now 20. For the purposes of this hypothetical, let's assume that the abuse did in fact cause that filing delay. Is Sandra eligible for a VAWA self-petition based on Alice's abuse? What do we think? Got 10 more seconds. Okay, so this was a tough one. The answer is actually no. And the reason for that is one of the requirements for this exception to apply is that the person was eligible for a VAWA self-petition the day before they turned 21. And for Sandra, that's her snag. She was not eligible on that day. Could anyone tell me why not in the chat? Exactly, because she was married, so she was no longer considered a child. So great job, everybody. Next slide, please. Okay, now for everybody's favorite topic, the Child Status Protection Act. So it's called the CSPA for short. That allows certain non-citizens who would otherwise age out of eligibility to be considered children if they meet certain requirements. And luckily, as long as the self-petition was filed or pending on or after August 6th of 2002, VAWA self-petitioners and derivatives are included in the CSPA. The protections vary depending on whether the non-citizen is seeking a benefit as a relative of a US citizen or as the relative of a lawful permanent resident. But in all cases, the non-citizen has to remain unmarried in order for those protections to apply. The CSPA rule is pretty easy for self-petitioning children and derivatives if the abuser is a US citizen. So in those cases, the non-citizen's age is going to freeze on the date the self-petition is filed, as long as they remain unmarried until their adjustment is approved. Things get a little bit more complicated if the abuser is a lawful permanent resident. In those cases, you have to find what is called the CSPA age. And to do that, you have to do a little bit of math, unfortunately, for those of us who don't like math. You have to subtract the number of days the VAWA self-petition was pending from the non-citizen's age on the day that a visa became available to them, or if they're a derivative to their parent. And critically, even if you succeed under this math equation, to get the CSPA protection, you also have to do something called seek to acquire within 1 year of that visa becoming available. And you can do that in many ways, including by filing a 485 adjustment application, or if the person's abroad, by filing a DS-260 immigrant visa application. This seek to acquire requirement within 1 year, it can be waived if extraordinary circumstances explain the delay, but that's really not something you want to rely on if at all possible. So this question is, how do you know whether a visa is available? The policy manual has 2 requirements for that. The first is that the self-petition does have to be approved. So they're not going to consider a visa available. Self-petition is just pending. And second of all, there has to be a visa available for both the preference category and the priority date. And you do that by checking the US Department of State's visa bulletin, which is linked in your materials. So now let's move to some polls to see how all this math works in practice. Next slide, please. We have Ibrahim. He filed a VAWA self-petition based on abuse by his lawful permanent resident spouse. Ibrahim properly included Omar as a derivative on the self-petition. The VAWA self-petition was pending for 3 years and 1 month, and a visa became available when Omar was 23 years and 5 months old. Omar is unmarried, and he applied for adjustment of status when he was 23 years and 5 months old. So that same month that the visa became available. What do we think? Can Omar remain in what the visa bulletin calls the F2A preference category for children of lawful permanent residents? About 15 more seconds. Okay, great job, everyone. The vast majority of you got this correct. And the answer is yes. And the reason for that is that we subtract 3 years, 1 month from 23 years, 5 months old. That makes Omar's CSPA age 20 years and 4 months. So he's still considered to be under 21. Only if, though, he remains unmarried and if he properly sought to acquire. We see that he has remained unmarried and that he sought to acquire by almost immediately filing his adjustment application. Omar's representative should advise him that if he marries before his VAWA self-petition, before his adjustment application is approved, he's not going to be able to adjust through VAWA. Next slide, please. Now we have Mira. Her father, Samuel, is a lawful permanent resident, and he abused her as a child. She properly applied for a VAWA self-petition based on Samuel's abuse. That self-petition was pending for 1 year and 8 months, and a visa became available when Mira was 22 years and 9 months old. She's not married. So can Mira remain in the category for children of lawful permanent residents? 10 more seconds. Go ahead and close the poll. So the vast majority of you, again, got this right. You are all way better at math than I am. The answer to this is no, and that's because we see that she was 22 years and 9 months when that visa became available, and the VAWA was pending for 1 year and 8 months. So that makes her CSPA age 21 years and 1 month. So she's no longer considered the child of a lawful permanent resident. Next slide, please. Assuming that Mira does not get married, what happens to her now? Give folks about 30 seconds to respond. So she can never become an LPR. She moves to this category for unmarried sons and daughters and keeps her priority date, or she moves to the sons and daughters category, sorry, and the priority date is the VAWA suppetition approval date. So what do we think? 10 more seconds. Okay, and we can go ahead and close. 56% of you said that she moves to this F2B category for unmarried sons and daughters of LPRs and keeps her priority date. And that is the correct answer. By statute, if the unmarried non-citizen's CSPA age is unfortunately over 21 or older, their petition is automatically converted to the appropriate visa bulletin categories. They don't have to do anything in order for this to happen. And they retain the original priority date, which would be the day the VAWA suppetition was filed. Unfortunately, because of backlogs, Mira probably will have to wait a significant amount of time before she can adjust. But luckily, by statute, she does remain eligible for deferred action and work authorization while she's waiting for her VAWA suppetition. Sorry, for her adjustment of status, the priority date to become current to file the adjustment of status. Next slide, please. The most important practice tips when you have a CSPA case are to watch the visa bulletin really closely, and then to file for either adjustment or an immigrant visa as soon as possible after a visa becomes available. And that's for two reasons. One, because you only have a year to seek to acquire, and two, because if there's retrogression, the non-citizen's age is not locked in. For example, if a visa is available in March, but then suddenly in April, it's no longer available, the client's age is no longer locked in. And those of you who are familiar with the visa bulletin know that retrogression does happen. So that's why it's really important to try to get this filed as soon as possible. And to make sure you could do that, it's important to advise your clients about, why it's important to file the AOS or the DS-260 timely, and to make sure that you're keeping their contact information current so you can really get on that application as soon as possible. It's also important to advise all your VAWA clients, even if the abuser is a US citizen, that if they marry before that adjustment application is approved, they're likely not going to be able to adjust through VAWA. Next slide, please. Any questions before we move to the next session or next section? Rebecca, did you see any questions?
Before I go to those, I want to just say some folks have been typing in questions related directly to the examples and hypotheticals you were going over. For those, it's a little hard to tell now that we've moved on which hypotheticals they went with, unfortunately. So anybody who was writing in the chat about those, if you are able to remember the full context of your question and rewrite that question as a standalone question in the Q&A box, we'll try to get to it. But yeah, one question that came in the Q&A box was, if a child derivative has an already approved I-360 before he ages out, but then the adjustment of status is still pending and he turns 21, does this mean he's aged out? So I think the fact that the adjustment of status was pending when he turned 21, that's going to be a red herring. That's really not necessarily part of this question. The answer about age out, it's controlled by the CSPA, and that depends on all the things that Kelly was going over, things like the status of the abuser, maybe the age was frozen, maybe not. How long was the I-360 pending before it was approved? How soon after the priority date became current did they file that I-485? All those things would be relevant to getting you an answer to your question. I also see a question that came in just to the panelists asking if you have a VAWA derivative who turns 21 and the principal parent is not able to adjust, that the local office will often say that a certain section of the INA controls and the child cannot adjust if the parent doesn't adjust, wondering if people have had success despite this being in a parent practice at a local field office. So I would say, yes, we have heard of success. This again is to that same rule about somebody who's a VAWA derivative aging into becoming a petitioner in their own, rather than using the Child Status Protection Act. We didn't go over that today, so I don't want to spend a lot of time answering this, but yes, it can still work. Yes, local field offices and consulates seem to need help understanding this, but you can make an appointment for technical assistance with ASISTA, and we can discuss the strategies that you'll need to help overcome it.
Right. And then also, I would say that it's incorrect of them to say that 203D applies. So that's 8 US Code 1153D, because that provision talks about child should get the same status as the parent if they're accompanying or following to join the parent. But what the field office doesn't seem to understand is that once that child becomes a self-petitioner in their own right, they're no longer following to join that parent. They're no longer a derivative. They have their own principal application. But yeah, definitely if you're seeing this, feel free to get in touch for technical assistance.
And there were no other questions that I see that have come in.
I saw one question in the chat about, would it make any difference if the abuser becomes a US citizen while the VAWA was pending? So that is a great question. Not 100% confident in my answer, but I'm pretty sure that would make things okay as long as the person remained unmarried. And that's because if the abuser naturalizes, the petition is automatically reclassified as a petition by a spouse or child of a US citizen. So that could save someone who otherwise would have. So that's a great question. And then the question about what about for children overseas after the approved? The issue there would be whether they've done whatever's necessary, do the CSPA age calculation. And then once you've done that, has the person done whatever's necessary to seek to acquire within 1 year of visa availability? So generally the way you do that if someone is abroad is by filing that DS-260 immigrant visa application. But you take a look at the policy manual, which is included in the materials, to see if there's any other options for seeking to acquire for people who are abroad. Next slide, please. So additional options for children outside of the United States. I'm just going to go through this really quickly. Next slide. So for T derivatives, there is this derivative of a derivative category, which is unique to T visas. It's not available, unfortunately, for use. For this category to apply, you have to show that there is a present danger of retaliation to a family member who's specified in the statute because of either the principal's cooperation with law enforcement or their escape from the trafficking. Say you have a client who is a T1 and they're cooperating with the FBI, and somehow the trafficker's associates in, say, I don't know, India, found out about the cooperation and they're threatening to harm the T1's grandchild who's 2 years old. There's potential that grandchild could be a derivative under this formulation here. Again, because this is not available for use, the option that you would have there is humanitarian parole. If you can show an urgent humanitarian or significant public benefit reason for the child to be in the United States. Next slide, please. Central American Minors Program, because you all actually don't have that much of a role to play in these types of applications. I won't spend too long on this, but just keep in mind that there is this program for qualifying children who are nationals of El Salvador, Guatemala, and Honduras, who are unmarried and under 21. And people who are considered eligible petitioners for CAM include parents or guardians who have a pending U1 or T1, as long as it was filed on or before April 11th of 2023. So if you have a pending U or T client who, fits within that date range, and they have a child in El Salvador, Guatemala, or Honduras, there's a chance that that child can qualify for CAM. Refugee Resettlement Agency does have to file that application. And if you have any questions about CAM, you can contact the International Refugee Assistance Project. Next slide, please. Okay, and I think this is you.
One last section for you all, talking about how inadmissibility grounds can be affected when the applicant is a child. Next slide, please. First of all, when does age matter for whether someone is inadmissible or not? It is really in two scenarios. First, there are some inadmissibility grounds that have explicit exceptions for children of certain ages. And these include certain criminal grounds and the unlawful presence bars at INA 212A9B. And then second, even short of an actual age-based exception in the actual provisions to inadmissibility, the fact that a person's a child might also sometimes provide a way to argue that the inadmissibility ground can't apply to a particular child. And a great example of this is the misrepresentation ground, because that requires a willfulness component. And if the person is too young or for some other reason cannot form that willful intention, then they would not be able to be held inadmissible. So we're going to talk a little more in detail about each of these now, and we will also be explaining how even if their age doesn't get them out of a ground applying, it may help them gain positive discretion in an application to waive a ground of inadmissibility. And so a child's age can be quite relevant when it comes to inadmissibility and waivers. So next slide, please. We are going to start with the criminal grounds. One way that age matters explicitly here is that many, although not all, of the criminal grounds of inadmissibility require a conviction to be triggered. And as it turns out, there is case law on this slide that holds that juvenile adjudications of delinquency are not considered convictions. This means that if your child client was charged with certain crimes or acts that would be inadmissibility grounds if they were charged as adults, if they are charged as a juvenile instead, they are not going to be inadmissible, even if the ultimate disposition is against them. In addition, while some grounds can be triggered by an admission to the essential elements of the crime and not just formal convictions, those admissions have to happen in compliance with a case called Matter of K, and that requires the person making the admission to be given an explanation of the crime and all of its essential elements in terms that are understandable to them. And that's pretty rare with adults, but with children, it is probably even more rare because the terms that they can understand are going to be even more limited. And so then for you to look over later, we've put on this slide some of the main criminal grounds that do require conviction or admission. But just remember, there are several that don't, and those would be prostitution, a reason to believe someone's a drug trafficker, and the health-based grounds where the person is a drug abuser or drug addict, which kind of overlaps with criminal grounds. So all of those things, if no convictions required, it's going to apply equally to children and to adults. The other place the age can help avoid an inadmissibility finding is with the so-called youthful offender exception to crimes involving moral turpitude, which is abbreviated CIMT. So CIMT, youthful offender exception, says that if a person has only one CIMT in their history and it was committed when they were under 18, and it's been more than 5 years since both the commission of the offense and the person's release from any sentence, then that CIMT will not make them inadmissible. Unfortunately, this exception does only apply to the CIMT ground and not to controlled substance offenses, for example. So it's a bit limited, but it can still be quite helpful sometimes. All right, next slide, please. So we have another example for you. This is Amara. She is 23 years old and she's undocumented. She wants to file a U visa based on domestic violence. And it turns out when she was 17, she was tried and convicted as an adult of a CIMT assault, which happened against her abusive father. She never served any time for this conviction, and she has no other criminal history. Can we please launch the poll to see, does Amara require a waiver of inadmissibility for this CIMT conviction? See some answers coming in. Get them in, get them in. What do you think? Give you 5 more seconds. All right, and let's close that poll. Slightly more than half of you said no, although it was a very close call, and this was hard, and I think we could have made it easier for you if we'd made her 24 now instead of 23. So sorry about that, but I think the answer is no, probably not here, because it seems like Amara is going to be eligible for that youthful offender exception. We can walk through it. It says she has no other criminal history, so this is her only CIMT. It was committed when she was 17, and thus she was under 18. And it was committed, we're saying, more than 5 years before this particular application, whatever we're going to submit for her. And she served no time. It's also been more than 5 years since any prison sentence could have concluded. And seems like that applies. And because the youthful offender exception is an exception to the CIMT ground, that means that the CIMT just doesn't make her inadmissible. And she wouldn't need a waiver for it. Sorry for the tough math there. A good job, everyone. Let's go to the next slide, please. All right, so we've got the same facts this time, except, so again, to recap, we've got someone who was tried and convicted of CIMT when she was 17, except this time what she was convicted of is a cocaine possession instead of a CIMT assault. Again, she never served time for the conviction and has no other criminal history. If we launch this poll, can the youthful offender exception help her with this one? All right, give you a few more seconds to answer. All right, let's close that poll. This time people were a lot more sure. Most people are saying no, and that is right. Unfortunately, the youthful offender exception is only an exception to the CIMT ground and not to a controlled substances offense, which is what a possession of cocaine offense would likely be. Now, you may have other arguments that she doesn't need a waiver. Maybe in her jurisdiction there is overbreadth for some reason. This possession offense might not qualify as a controlled substance conviction. There might be some other reason that she wouldn't be inadmissible, but unfortunately, it's not the youthful offender exception that she would be able to turn to. All right, very good. So next slide, please, which I think is over to Kelly.
Thank you, Rebecca. So even though there are some exceptions to criminal grounds of inadmissibility for children, as Rebecca mentioned, they're not universal. Also, a juvenile adjudication of delinquency, which while it's not a conviction for immigration purposes, unfortunately, it is still considered a negative discretionary factor. It's often necessary to make discretionary arguments for immigrant survivors who had childhood contacts with the criminal legal system. Most of you probably have a lot of experience making discretionary arguments, but there are some specific factors to consider when the person's contact with the criminal legal system occurred when they were a child. So I have a quote on the slide here from Roper versus Simmons, which is the first in a long line of Supreme Court decisions about children and sentencing. And the overriding theme of these decisions is that children are different. And the Supreme Court they've used that truth that children are fundamentally different than adults to hold that children and adults should not be treated the same by the criminal legal system, even if they've committed very serious violent crimes, probably not the types of offenses that your clients have committed. You might be wondering, okay, how are these decisions relevant to immigration? They express some universal truths about children's brain development, their behavior, their characteristics, their capacity for change that really have become a part of the Supreme Court canon, have been repeated time and time again in multiple decisions. And that's not something that USCIS can just ignore. And while these decisions are about the most severe criminal sentences and not about immigration, the Supreme Court has, in a long time decision from a long time ago, compared deportation, which is a possibility if survivor-based relief is denied. They've compared deportation to banishment or exile. So that means, in effect, that deportation is the immigration version of life without parole, which is one of the sentences that were at issue in these Supreme Court decisions. And so the Supreme Court's reasoning on why life without parole is inappropriate for the vast majority of children is instructive as to why the immigration version of life without parole is often going to be inappropriate for survivors who had contact with the criminal legal system as children. Immigration adjudications, they do have to be fundamentally fair. You can argue that it's not fundamentally fair for USCIS to say that an otherwise eligible survivor, a person who met all the requirements for a U visa, all the requirements for VAWA, for example, to render them vulnerable to deportation, this immigration life without parole, solely because of their childhood contacts with the criminal legal system, without at least acknowledging that there's this Supreme Court precedent that says that children are less culpable for the same behavior than adults. Specifically, Roper, the case on your slide, it held that the differences between children and adults, quote, render suspect any conclusion that a juvenile falls among the worst offenders. Yet a USCIS decision to deny relief as a matter of discretion because of the survivor's juvenile record essentially is saying that this person is among the worst offenders, that they're not eligible, they're not deserving of mercy or protection they're otherwise eligible for. We're going to say that they haven't been rehabilitated, they're not capable of rehabilitation. And the Supreme Court has said that's a suspect conclusion to make about a person who committed an offense as a child. USCIS judgments about discretion, they often come down to this nebulous concept of, has this person been rehabilitated? And these Supreme Court decisions clarify that because of the unique characteristics of children, they have greater capacity to change than adults do. And you can use that to your advantage to show not only is this person uniquely capable of rehabilitation because this offense occurred when they were a child, hopefully also that they've actually been rehabilitated because look, now they're an adult. They're more mature. They're not susceptible to the outside influence of the wrong crowd. They've learned their lesson, all those types of things. I want to caution that the argument is not that because the survivor was a child, their behavior is okay, or that's an excuse. Instead, it's that the age provides context for their behavior and that it is relevant to USCIS's analysis of the blameworthiness of that behavior, so how bad that behavior is, as well as their capacity for rehabilitation. It's absolutely necessary still in these cases to show what some of us, the 3 R's, remorse, responsibility, and rehabilitation. But if you can show that the survivor possessed some of these characteristics that the Supreme Court has mentioned, like immaturity, susceptible to outside influence, being impulsive, if you can show that the survivor possessed some of those characteristics at the time of the offense, show that they, don't have those characteristics anymore now that they've matured, and that ideally they have not committed any additional offenses now that they're adults, you could argue that, look, this person has been rehabilitated. And in fact, there is a paradigmatic example of children's capacity to change, which has been something that the Supreme Court has recognized time and time again. And Rebecca, I think it's you next.
Next slide, if you will, please. All right, so that was all about criminal inadmissibility grounds, discretionary arguments for waiving those grounds. Now let's talk about another type of ground where there's an explicit exception for how it applies to children. It's the unlawful presence bars, also called the 3 and 10-year bars at INA 212A9B. So these bars are triggered if a person accrues a certain amount of time in unlawful presence in the US, specifically more than 6 months to 364 days for the 3-year bar, or a year or more for the 10-year bar. If they accrue that much unlawful presence and then they leave the country, that will trigger one of these bars. Bar is not triggered if the person's unlawfully present in the US for a long time, but never leaves the country. Assuming your client has actually accrued this unlawful presence and departed, the thing that to look for with kids is that any time in unlawful presence that happened before the child turned 18 does not count towards the bar. If a person was present unlawfully in the US for years and years, starting at age 2, and then right when they turned 18, they left the US, that departure does not trigger the 3 or 10-year bar, because those years in unlawful presence before their 18th birthday are not going to count against them. Now, if they waited until they were 20 to leave the US, they would have accrued about 2 years of unlawful presence, right? You would count from turning 18 until the date of departure. And so that would trigger the 10-year bar on departure. Unfortunately, this special rule about not counting time before age 18, it is only for the 3 and 10-year bars. And it's not for the permanent bar can be triggered by unlawful presence. But that's unlawful presence that happens at any age if after the departure, the person returns to the US unlawfully or attempts to. So if you've got a client who was here unlawfully as a child and then left even before they were 18, if they return EWI, do not assume that they're off scot-free just because the age exception is going to save them from the 3 and 10-year bar. Unfortunately, even if their unlawful presence all happened under 18, if they leave and they come back EWI, that unlawful presence will still count against them to trigger this permanent bar. All right, next slide, please. Finally, we want to talk about those inadmissibility grounds that don't have an explicit exemption for children, but which children might not trigger because these grounds contain a mens rea element. The biggest one of these is the fraud or misrepresentation ground. To trigger this ground, the fraud or misrepresentation has to be made willfully. And that is interpreted to mean that it has to be made with the knowledge that it is false. And so some children will be too young to have this knowledge, or for some other reason, they will not be able to be willful about a misrepresentation, and therefore they won't be inadmissible. Now, of course, unfortunately, it's not as simple as USCIS giving us a bright line rule to apply to minors. Of course not. They're not going to say that anyone under a certain age will be presumed incapable of forming the requisite intent. No, instead, USCIS policy manual says it's going to be a totality of the circumstances question here, and it will turn on several factors, many of which are actually related to the person's age in a way. You can see here, they include age straight up, but also a person's subjective maturity, their education, their level of understanding of what they were speaking about, their subjective ability to appreciate the difference between true and false, and then other relevant facts about their background and their mental capacity and their circumstances. Again, it's a totality of the circumstances test. So you're going to have to make an argument and present evidence about your particular child client if you want to assert that they are not inadmissible for giving false information due to not being able to be willful about that false information. So next slide, please. And I know we're getting towards the end, but we'll do this quickly. We've got someone named Sophia who, when she was 12 years old, her mother gave her a fake border crossing card. It contained her real name, and her mother told her to present this card to the border agent. The next day, Sophia, her mother, and her mother's friend drove up to the port of entry at the US-Mexico border, and as instructed, Sophia presented the fake border crossing card to the border agent. The agent quickly glanced at the fake card and the other passengers' genuine documents and waved the whole group through. Now, Sophia's an adult, and she's consulting you about inadmissibility. For the chat, if you can, what would be some questions that you would have for her to be able to tell if this is going to have made her inadmissible? So thinking back to those factors that we read out. We know her age. She was 12, right? Do we know her level of education or level of understanding? What are questions that would get at that? For the sake of time, I will say things that I would want to know. Yeah, did she know this was fake? Very good. Did she understand what it meant for it to be fake? When did she learn it was fake? Very good. I think her being 12, some 12-year-olds might know that they're not allowed to enter the US unless they have a certain document. And I think some really might not know that. So find out what she knew. Basically, you're just trying to see if any of those factors, age, level of education, background, could she read the card to know it was false? Did her mother tell her how she got the card? All these things. What did she know about the card? What did she know about the right to enter the United States and what a card would be used for? That's what you need to know. Have her put in a declaration if you do think that she was unable to be willful about this representation. Very good, everyone. Let's move on to the next slide. And this final topic is a little outside the survivor-based wheelhouse that ASISTA focuses on anyway. So this is UAC asylum. UAC stands for unaccompanied child. A UAC asylum claim is defined as one that's filed by an applicant who, at the time of entry into the US, and maybe at the time of filing, is under 18, has no lawful immigration status, and has no parent or legal guardian in the US who's available to take custody of them. Now, unfortunately, because this is a bit complex and out of our wheelhouse, and we really don't have time to go into it today, we're not going to give you a lot of details, but we did think that we wanted to flag it for you because I'm sure a lot of you have clients in removal proceedings who might be eligible to pursue UAC asylum on top of the relief that we talked about today. We really wanted to remind you, this is an area with very special rules for children, special procedures, and the ground is shifting on it a lot under a class action called JOP versus DHS, as well as a BIA case that's a bit in conflict with that. And so it's something to keep an eye on. We put some materials in your webinar resource handout on this to help you learn more, and just wanted to say keep your eyes out on this topic. All right, next slide, please. Got a final question slide. Kelly, did anything jump out at you? I think we've got 1 minute for questions.
So someone was saying in the examples, does the requirement that the trafficking victim be present in the US due to the trafficking not apply? So that requirement so that's when you apply for a T visa, you have to say that you're physically present in the United States on account of trafficking. That requirement does still apply to children. There's nothing in the statute or regulations that says it doesn't. So you'd be using the same types of factors to assess physical presence that you would be for an adult, keeping in mind that if you do use that cooperation exception, you won't be able to use law enforcement cooperation as a way to say you're physically present. So sometimes if people are applying for a T visa and they want to say that they're physically present, some people who are cooperating with law enforcement will say that, oh, I'm physically present because I'm cooperating with law enforcement. If you use that cooperation exception, you can't really make that argument, but you still have other ways to prove it. Like you're receiving trafficking specific services here in the United States, you have a civil lawsuit, something like that. You do still have to show that as a child. This webinar recorded? If so, where can I find it? Yes, it will be recorded, and Maria Lazarino, our program associate, will email the recording out to everybody once it's ready. think that is all we have time for today. Thank you, everybody, for coming and especially for your participation. Made it really fun. So hope you all have a great day. Bye.
Do you want to go to the next? Oh, that's okay. And anyone who's still here, the handouts do contain information on getting our access to our TA portal to ask questions on strategy advice of our staff attorneys. Thanks, everyone.